I don't have any way to
While
get
in,
cash in our
ma'am, you
county.
want to keep interrupting me?
Uh, I'm sorry, sir.
Court calls case of the people versus Marquita Simmons. She's on. Thank
Assistant County Defender Natalie Plea for Mrs. Simmons, who should be present via Zoom.
you. Looks like she is. Can you state your name, please?
Marquita Simmons, sir.
Clear on behalf of probation. Your Honor, Ms. Simmons is before the court for a violation of probation hearing. She is at her 2-year max of probation term. She owes a balance of $3,775. She's made no payments towards for fines and costs and/or restitution. She's failed to report to probation as directed, failed to complete the theft class, failed to complete her 25 hours of community service, failed to complete or submit her fingerprints. She also failed the bench warrant out of the 15th District Court. Given all of the violations in this case, probation is asking that she be remanded to 365 days in jail, that she complete the in-jail MRT program, with the court to consider an early release upon completion of that program, waive remaining terms, accepting the financial obligation, and discharge from probation.
Thank you, Your Honor. Did have the opportunity to discuss this with Ms. Simmons on a few occasions. We did discuss both the alleged violations as well as the recommendation. Ms. Simmons does acknowledge and admit that she has violated probation in those alleged ways. However, as to the recommendation, she represented to me that she is a single mother to a 4-year-old nonverbal autistic daughter. And very unfortunately, she did struggle with homelessness starting in December of last year. Last month, she was able to get into state housing in Flint. We are respectfully requesting the court to consider discharging Ms. Simmons from probation without improvement, but in ordering the restitution, of course, or continuing that order, but we are asking the court to consider not remanding her at this time. Ms. Simmons does acknowledge and take responsibility for the violations, but she is very concerned that if she was remanded, certainly to serve a year in jail, that her 4-year-old daughter would have, frankly, nowhere to go, and she has nowhere else that would care for her, and that we would respectfully request the court to not remand her or order any jail time, but to just simply discharge her from probation without improvement.
But she's done nothing.
And Your Honor, I would also like to state this case started as a felony. I mean, the court is aware of that.
Yeah.
It was reduced down to a misdemeanor, and she's made no effort to get any of the things done. I do know that she had some communications with my office indicating that she was never told, which they
Never told what?
that there was many attempts made by my office to get her back into compliance and or reach out to her. The only time that probation started to hear from her with any consistency was yesterday before court.
No, excuse me, Judge. May I speak, please?
Yes, go ahead.
I never even met Miss Ellen. After the court date and all the appearances and things like that, I tried to contact her to see what the stipulations of my probation was. She never contacted me.
Hold on. You're telling me you tried to contact my probation office and they didn't call you back?
Yes, sir. I
I do
emailed.
not believe that. I don't
Yes,
believe
sir.
that for a minute.
Yes, sir. I don't have no reason to lie on this lady or myself, sir. I did report where I was supposed to, and I contacted her, and I talked to the secretary lady. A lot of times she was always in court, and she said she'll give her the message to call me
Ms.
back.
Polera is only in court with me 2 days a week max. So that I know that's not true.
I don't have to lie to
If
you,
you
sir.
want me to go pull the phone logs, we can tell exactly when you may have called. What dates did you call?
It's been a long time. It's been over a year since I've called. That's been a long time. It's been over a year.
Your Honor, I can tell you I've received a total of 3 report forms from her in the 2 years.
Three report forms.
3. A total of 3 in the 2 years. I had phone conversations.
Well, just so the record's clear, that's a monthly reporting form.
Correct.
So if my math's correct, 2 years is 24 and only received 3.
Correct.
So we're about 21 short. Go ahead, Ms. Blair. I'm sorry.
I also spoke with her directly on March 20th. The violation of probation hearing was set then. When I spoke with her on that date, all I got was a lot of, I'm not gonna do that and I can't do that. And I advised her that this court date,
finances. I don't have
that
the
this court date
finances,
was
and I
set
kept
out to
telling
give her
you,
some time to get things completed, and she's done nothing.
I don't have the finances. If you're taking care of a 4-year-old autistic child, what finances do you have? I don't have the finances to pay for restitution. I've been said this in court a long time ago.
You had a felony that got reduced to a misdemeanor. You took the misdemeanor, got placed on probation for the longest you could. Give that time. You want to keep interrupting me? You go right ahead. And then you did nothing. And then you come before this court. You know, you don't even file the monthly form. That doesn't even require you to be there. You did that 3 times out of 24 times. You did you did nothing. And then you get here, and you know, the problem, you then try to blame Miss Plea that she didn't call you back. First of all, in the years that I've worked with Miss Plea, that doesn't happen. You tried to call out and tried to blame the wrong person.
Right.
Anything else, Ken?
Nothing further.
Defendant is remanded to serve 365 days Washtenaw County Jail. I'm ordering that the defendant report to the Washtenaw County Jail by 6 p.m. today. Failure to report will result in a bench warrant. That bench warrant will issue without bond.
I don't have any way to
While
get to Washtenaw
ma'am, you
County.
want to keep interrupting me?
I'm sorry, sir.
While in jail, the defendant is to complete the in-jail MRT program. I will consider early release upon completion. I will waive the remaining terms, accept the financial obligations, discharge the defendant from probation without improvement. And if you want to believe that I won't issue that warrant, ma'am, try me. Thank you.
Judge Simpson, how would I supposed to get down there at 6 p.m. with no transportation?
Yes. Yes, we do.
Assistant Prosecuting Attorney Morgan Burroughs on behalf of the people waive the potential conflict between this honorable court and public defender's office. The people do not believe that that's the reason they display their evidence against that.
Good afternoon, Assistant Public Defender Laura Parody. The Public Defender's Office likewise does not believe the conflict exists, but if what does, we do something.
All right. And the court, for its part, also does not believe that there is conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. I'm out.
Yes, sir.
Court does call the case of the people of the state of Michigan versus Alexis Naveen.
Prosecuting Attorney Morgan Burroughs on behalf of the people. Good afternoon, Assistant Public Defender Laura Parody on behalf of Ms. Lee. Thank you. State your name, please.
Salad.
All right. This is your motion regarding release.
Yes, Your Honor.
Go ahead.
I would rely on the writing. We have had an off-the-record conversation. I have got some more information from my client that I would like to provide. Her plan, if she were to be released today, is actually to turn herself into the emergency room or report to the emergency room. She plans on going to St. Joe. Because what I've written and explained to the court, she believes her body is in a PTSD cycle, essentially, and which has affected her nervous system. She wants to go to the emergency room, inpatient psych situation so she can stable her nervous system immediately from if she were to be released. She wants to go to St. Joe to stabilize her nervous system because of the PTSD that she's been diagnosed with and has been suffering ramifications of while in custody. When she'd be released from the hospital, she does plan on returning to the hotel that she was staying at previously. Her belongings are there, and they are holding her belongings there. She is able to pay for that hotel with both personal funds and insurance claim funds from USAA. There was another house that was not the house that is the marital home that flooded. The family does not stay there. It is only in my client's name. That house flooded, and my client filed a USAA claim, not with the VA as I previously understood, but with her insurance company. She has not received those funds because she did have someplace else to stay, which was the marital home. She now, according to the court orders, cannot return to that home, so can contact her insurance agent and have access to those funds. And she also can pay for a hotel to comply with the court's orders from her personal funds as well, as a backup. So that is the plan if she were to be released today. And I have explained to her the importance of following court orders. Make sure that everyone's safe in this case.
Okay. Let me stop you, and I'm going to have some other questions, but as we were in chambers talking, one of the things that the court had indicated, and I think I had indicated in a previous proceeding, was regarding a tether. The difficulty is going to be is that if she goes to the hospital,
She maybe might have to take that tether off. My thought would be if she were to go to the hospital, report to community corrections when she's released and stabilized to get placed on tether.
well, because I'm not saying no just to make it difficult. I'm saying no because we had a very quick violation of the bond conditions. Because of the circumstances of this defendant, I'm considering release under a very sort of stringent criteria, keeping it on a short lease, making sure that we're looking at it. But one of those criteria was the tether. Now, I understand that while we were talking, I think you just got this information about going to St. Joe's or the Trinity. And that complicates the issue regarding the tether.
She says she can report, she can go to the place with the tether, go to the hotel. Her medication is there. We did discuss reporting to the VA to get those extra services in chambers, and she's very willing immediately to contact the VA to get that extra support. So if the court's I see the court's point. If the court's unwilling to release her, if she were to report to the hospital, if she were to be released, go to the hotel, get her medication, get stabilized, and report to the VA or engage the service of the VA as soon as possible. With the social worker contact that I have, that I can provide her the number as soon as possible.
Ms. Baruso.
Your Honor, if the defendant's needing some sort of inpatient stabilization, I have no issue with her being released for an inpatient time period, but I think that would need to be the purpose for her release as opposed to a release for all of these other things. And I would like to have an inpatient location identified and secured prior to release. I think my concern mirrors what the court's concern is getting her there and what happens immediately afterward.
Well, and I don't, while the defendant has a plan, I don't know that she goes to Trinity. I don't know that they're going to keep her. I mean, she's indicating this is what I want to have happen, but the moment she gets there, and if the medical professionals decide no, then what?
If no, she would go to the hotel where she's staying and contact the VA for the additional services that they are willing to provide her.
But the question becomes, if she's on a tether, is all of that going to happen? Because if I say she gets released, tether prior to release, so they get her out, get her on tether, she goes to the hospital, they take the tether off. They're trying to make an assessment then as to whether or not they're going to keep her someplace inpatient or what they're going to do. The tether comes off, potentially. Then they make the decision, she's not there, we have a problem.
I don't know, and to be honest with you, I don't know if the hospital would, I can't say if the hospital would take the tether off or no.
I know, and
They may keep it on, they may take it off, I don't know. I think
it depends, at least I may be wrong on this, but I think it's going to depend upon what kind of testing they would do. I mean, some of certainly their diagnostic tools, she can't have that on.
and maybe the extended services that she needs after.
Right. I mean,
I think my thought is just if they were to take the tether off or something happened to the tether, this court could order her to immediately get in touch with defense counsel, get in touch with community service or community corrections, or tether agent, if that were to happen. At this point, we don't know. The other option, I think, is to order her to just get the tether, go to the hotel, get her medication, be in touch with
can I ask why wouldn't you obtain services from the VA hospital as opposed to Trinity?
Should I answer your?
Sure.
So I would like to go to Trinity I'm a trauma therapist. So PTSD is actually a central nervous system issue and a brain issue connect. So every door that's slammed, every key that I hear is like a pulse to my body. It's like a pound, right? Because my nervous system, when I hear it, my nervous system will jerk. I've tried to use all of the skills that I know as a therapist to stabilize myself. I can't stabilize myself. I don't have medication. And so I was going to go to the emergency room, asking for my medication there. I don't anticipate that they're going to need to take my tether off. I would like some medication. It would just be faster if I went to the emergency room. I did not anticipate at all that I would need treatment where a tether would need to be released. Then I would follow up with PTSD clinic at the VA. But what I'm seeking is that initial care that will make it easier for me and faster, that I am fully capable. It would just take me a little longer. I'm fully capable of being able to stabilize myself, which is why I've done so. It doesn't look like I've done well, but I've actually done very well here because I do have those skills. And if I have the medication and have the skills, I'm able to do that and always help. I will not go anywhere near anyone. I will take care of myself. That's my priority. I'm fully able to do it with other. I can do it at the hospital. I will make it.
She's residing where?
If she were to be released, she would be at the Holiday Inn Express on Research. I could provide the court with the exact address if you'd like.
That's fine.
I'm sorry, thank you.
That's no, we can get that information. So I'm just posing hypotheticals to try to come up with something, but if she's released on a tether, goes to Trinity, and let's say they're going to keep her for whatever the reason, how are we going to know?
Well, if the court orders GPS tracking, we know she would be there.
They take it off, then no, we wouldn't know.
Right, if she was there and that was the last place, we may be able to assume that that's what happened. And my office can of course follow up with, we have a release of information for my client, so we can of course follow up with the hospital to follow her treatment plan. If what was recommended by the doctors. My client saying that she wouldn't, if she were in the hospital, they wanted to cut it off, she would tell them not. I suppose she could leave the hospital against doctor's orders if they wanted to.
Okay, so, and here's part of the problem. Part of the problem is I might be able to sort of launch out and say, I'm going to go out on a limb and trust this individual to do that. The problem is I already have a bond violation. And so it becomes a bit difficult to say on the defendant's word that she'll do this when that's what happened before. And it didn't work.
I think, as I've seen it previously, I understand there's this bond violation. At this point, I'm worried about my client's well-being, and that's why I filed the motion. And I appreciate the court working with us to try to fashion something. But at this point, I think I've met with her multiple times. I'm worried about her. I want her to get out, be stable, and all we can do is say she's learned from this experience, and that she won't do it again. With the extra support of my office. I mean, when she was arraigned and released, we had not even connected because, as the court knows, it was so quick. The bond violation. We now have a relationship. She has a relationship with our office. I've reached out on her behalf to the VA, and they know about her situation. I think at this point there's even more.
Yeah, but I hear you, but even in that short little window, I don't have all of the services of the VA in place either, because those have to take place at a certain point, which we were doing, and she's, I understand, agreed to place a certain structure around what's happened. Ms. Barossa.
At this point, I am also concerned about the victim's well-being. So it's not just the defendant's well-being that's in question here, but we didn't receive an answer as to why she wasn't going to go to the VA as opposed to St. Joe's. I don't know why she would not go there. She said she has meds at the hotel. So if this is really just about efficiency, she can go to the hotel where they're holding her belongings. But I think based off of all of this, we've had a lot of shifting. I will. She's set to appear on Monday. Why don't we keep her until Monday and see if we can get a bed at an inpatient location, if that's what she needs, or at least get something more structured in place until Monday, or by Monday, because at this point, it doesn't sound like there's plans in place to provide the necessary security to ensure that there's not gonna be another bond violation and that the defendant is going to have the supports that she needs to be able to succeed when she's out of custody.
I would disagree. I think we presented the court with two plans as for next steps. She gets the tether, she reports to the hospital, gets the services that she needs. The hope, right, is that she keeps the tether on. The other option is she goes to the hotel, stays in touch with our office, stays in touch with, or gets in touch with the VA as quickly as possible.
Well, but, okay, so here's the problem. The difficulty that I'm having with all of this is we were in the back for an hour or whatever, and we're fashioning something to effectuate a release, but do it in a manner that certainly the court is comfortable with in terms of doing that. And I think we have something in place because certain things are going to happen in sequence. We'll know everything. And then I come out, and I'm not necessarily blaming anybody, but then the plans have changed. And I'm still curious as to why all their services set up through VA for this individual. So I'm curious as to why there is this desire to go to Trinity prior to the VA. I mean, I'm not understanding that.
I think this information and this plan was what she provided me in lockup. She's willing to go with the original plan of what we were discussing in chambers. I think where it comes to Trinity, I'm not allowed to speak to why Trinity versus the VA. I don't know. So if the court would like an answer to that.
I mean, I'll hear from her, but go ahead.
Thank you, Your Honor. I was actually trying to go a step further to take care of myself, as opposed to just going, I am happy to go to the hotel, I can do that. I did not know that we had not met yet. That was what we had discussed, and I thought, okay, well, I'll go to the hospital first. And the reason I say St. Joe's is because they're a little more kind and compassionate than the VA, and because I know what I was seeking, the service I was seeking. I was just seeking hydration. I was seeking medication. I can hydrate, I can medicate, I can Pedialyte, I can care for myself just as well at the hotel. It might take me 3 days as opposed to 24 hours, but that is not an issue whatsoever. And I apologize that I apologize if it seems like I'm trying to change the plan or I'm trying to get St. Joe and not the VA. That wasn't the intention. They're just nicer and they're a little more kinder at St. Joe as opposed to the VA. I am happy. I am 100%. I will go to the hotel. I will stabilize myself and I will reach out to the VA as soon as possible. I'm not trying by any means, or I'm not trying to manipulate. And the truth is, my safety is important. I agree with the prosecutor. So my family safety is actually, and that is more important. And I will not ever, to the best of my ability, ever, my family or I will not do that. And I know that's coming. I apologize.
Ms. Perny, your understanding of the initial contact with VA, right? That initial contact that you would make would be via phone.
I don't think I understand your question completely. To clarify, I've spoken with the social worker at the VA. She said that Ms. Naveen can call as soon as she's released directly to her number, the contact that I've had.
And that's the process, and I may have said it inartfully, but that's the process that begins to set up what we're hoping is a more structured type of.
Correct. They will do a analysis of our needs and connect her with any more supports that they deem are necessary.
So, ma'am, I guess I'll start here. The first thing you need to understand is there's to be no contact with them. You understand that? All right. That just cannot happen. And if it does, I'm just gonna just as fair warning to you. If it does, then what's gonna happen? You're gonna be back in Washington County Jail, and I'm not. Council can file whatever motions they want to file. I'm not gonna hear it again. Am I understood? And when I say that, no contact, I mean no contact through third parties. You understand that? No phone contact, no social media, nothing along those lines in terms of contacting the victim in this case. Understood? All right. Now, the other part of it is, and I think I'm going to do it this way because I don't want the plan to, whatever plan it is, to fluctuate. I mean, I think everybody here is trying to do what we can, and ultimately it falls to my shoulders to try to make sure that we can have the opportunity to get things in place. Part of the problem is that certain services that might be available to her through the VA aren't going to happen while she's here in custody. So I want to see the defendant get those, at least begin that process of getting those services. At the same time, I am not, by any stretch of the imagination, which is the reason that you're incarcerated now, I'm not going to tolerate contact. So here's what I think I'm going to do, because we're set for Monday for a pretrial and a sentencing on the bond violation on Monday. I'm going to release the defendant on a PR after but she has to be placed with a GPS tether prior to release. The initial phase of that GPS tether will be home confinement to the Holiday Inn Express. She can then begin the process of contacting the social worker to begin to do that. I will permit, even though it's home confinement, that the defendant may travel to appointments with the VA. So if they can start something up, like if she calls once she's out, they can start something up, she can go. Right? But then she immediately needs to come back to the tethered location. Okay, so, and Ms. Levine, so that you also understand, I understand the issue regarding compassion, your perception of that. I don't know that for sure, but okay, I get that. But that part of it's not happening. Understood? So when you get that tether, you got to head to that address. If you don't, I'm going to revoke the tether. You're going to be right back in. If you decide to try to maneuver or change something within this, you're going to be right back. So one of the things I'm going to suggest to you is, if you're thinking about making a move and doing something, that you get in touch with Ms. Perrone, that you get in touch with your attorneys before you make that decision. Am I understood? So when you get that tether, it's home confinement, that's where you go. You make the call to the social worker at the VA. start that process along the lines. If they can get that moving, you're permitted to go to those appointments, but they've got to be documented that you have those appointments. I will, Ms. Perry, then I will then reevaluate this on Monday, but at least this begins the process, and maybe we'll have some additional information about the structure. And I do that on Monday when she appears for a retrial.
Right.
Okay. Anything further?
Nothing further.
All right. And Ms. Perry, if you could get from your client the full address of where she's be staying, including a suite or room number.
Sure,
Okay, I just don't want to put it on the record.
sure.
Okay.
And then she'll provide that to the tether agent or this, or both?
Provide it to the tether agent. Actually, yes, provide it to the tether agent. Court calls the case, People versus Jeremiah Stanley.
There's just a couple of vendor warrant attorney on behalf of Mr. Stanley. Correct, you have you taken the record.
You have them or no?
Can you hear me now?
Yes, I can hear you.
You're
I need a camera.
I've tried to turn it on. I don't know how things have
Well,
changed.
that you were upset about having to wait, so now we have to wait until you can turn your camera on.
Can you see me now?
Amazing how that works.
Yeah, it just gave me an option, sir.
Your Honor, I did review probation's recommendation regarding the violation. We do ask that you adopt the recommendation. Mr. Stanley and I, conversation about the piece of complete. He says he's going to work on that as soon as possible. He is going to provide Ms. Blair with his work authorization or work proof. And again, we ask that you adopt that recommendation today. And we did talk about the wait. He is very concerned because he's at work right now.
I'm sorry that my life happens to have emergencies. I'm on the bench every day. And if you
fine,
think
sir.
for him, I'm going to leave my daughter out on the side of a highway, not going to happen.
I'm sorry, sir. I totally understand it. I had a friend of myself. I had a friend of myself commit suicide this morning. I've had a very difficult morning, and I'm.
Ms. Polero, what did you want to tell the court?
Your Honor, I just wanted to provide to the court that Mr. Stanley is in violation of the terms that was ordered by the court. Probation would ask that the court give Mr. Stanley a chance to complete probation terms, and is recommending that he serve 3 days in jail, credit for the 3 days that he served, that the balance of his $975 be paid by the application of his bond that he posted, that the court extend the prosecutor deferred for a period of 9 months, that he report to probation tomorrow at 11:30 a.m. in person, then as directed, that he become compliant with all previously ordered terms of this court within 30 days, with the final review hearing February 12, 2025 at 9 a.m.
Sir, anything you want to say before I impose sentence?
I agreed to give over the bond money to pay for the fines. That was the money I was saving up. I'm sorry that I failed to comply with the fingerprints and the outpatient therapy and everything else. I want to keep my job and not go to jail and lose it possibly.
Sentence of the court, 3 days Washington County Jail, credit for the 3 days that he served for the violations to date. He's to pay $975 or $975 balance today. I will apply the bond, which will account for 900 of that. The balance has to be paid today. I will extend his prosecutor deferred sentence for a period of 9 months. I'll order that the defendant is to report to probation on Thursday, May 9th at 11:30 a.m. in person, and then report as directed. He is to become compliant with all previous ordered terms within 30 days. I will schedule a final review hearing on February 12th, 2025, 9 a.m.
Sir, is there any way that I can show up tomorrow to pay the remainder?
Fine. Pay it tomorrow.
All right, thank you, sir.
Are we done? Thank you.
Yes, sir.
Court calls the case, People versus Damon Watson.
Good afternoon, Assistant Public Defender Laura Kirby on behalf of Mr. Watson. I don't believe Mr. Watson is present. Really good role here. This, I don't actually heard the hearing on our desk for the
Please declare on behalf of probation, Your Honor, given that Mr. Watson should report to court for a violation of probation and not complying with the terms of the court probation's request.
Bench warrant will issue for defendant's failure to appear, bond 10,000, 10%. That warrant will issue immediately. Court calls the case, People versus Samuel Hamilton.
Good afternoon, Assistant Public Defender Laura Kirby on behalf of Mr. Hamilton. Mr. Hamilton, can you unmute and state your name for the record?
You're just having a great day.
Happy to be here. However, this week was Hamilton just yesterday. I don't know why he's not here and asked for the show.
Bench warrant will issue bond 10,000, 10%. That warrant will issue immediately. Court calls the case of the People versus Marie Offrey.
For Ms. Crawford, who I believe should have made a $270 payment last night.
You mean she should have paid off her balance?
Correct. She has a zero balance, Your Honor.
So it seems things are going well for Miss Page. Miss Perrine, you may want to take a lesson for that. I'll cancel the show class.
Thank you.